All rise.
Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Superior Court of Justice is now resumed with the Honorable Justice Hennessy presiding. You may be seated.
It'll take me 1 second to get my screen up.
And just noting that our intention is to start this morning with Mr. Gover, who will be appearing virtually.
Oh, very good. Oh, there he is. Good morning, sir.
Good morning.
I'll just get my screen up.
Yes, thank you, Your Honor.
Thank you. When you're ready, Mr. Gover, please go ahead.
Thank you very much, Your Honor. Brian Gover appearing on behalf of the Contingent Interest First Nations and to make the balance of their reply submissions. But I begin this morning by returning to the question that Your Honor asked Mr. Bass at the end of the day yesterday regarding the Supreme Court of Canada's desire that the parties rekindle the relational aspect of the treaty. And in that respect, Your Honor, you took Mr. Bass to paragraph 300 of the Restool decision. And I add this to Mr. Bass's response to the court's question. The court's, I speak now of the Supreme Court of Canada's references to the relational aspect at paragraph 300 must be read alongside the court's discussion of the remedies available to this court at paragraph 310 of the decision, which is now displayed on the screen. And what I emphasize is the portion that begins about 5 lines down from the top. However, if the court finds that the Crown's process or determination was not honorable, it may consider the appropriate remedy, including whether to remand the issue to the Crown for redetermination or set the amount to be paid by the Crown, and then these important words, lest the Crown continue to undermine the very object and purpose of the treaty promise. That is, the court gave the Crown an opportunity to remedy its long-standing breach of the treaty and to revive or renew the relational aspect of the treaty through the engagement process. However, the court recognized that if the Crown failed to uphold the treaty and really continued to fail to uphold the treaty and the honor of the Crown, I say that in view of the findings made by the Supreme Court of Canada throughout its decision. The Supreme Court of Canada clearly held that this court may have to step in to prevent the Crown from continuing to harm and undermine the treaty relationship. So, where this court cannot have faith that the Crown will now uphold, and to return to the language used in paragraph 310, the very object and purpose of the treaty promise, including the nation-to-nation relationship at its core, the Crown cannot continue to allow them, that is, either emanation of the Crown, to undermine it. Now, further, regarding the engagement process, let us recall.
May I ask you to hold for a second? I'm not seeing from the report or anything on my screen. I'm not sure if anybody else is. You are? You are? Oh, it's just me. Might have a workaround coming. Well, I can live with it. When you're ready, please go ahead. Thank you for that indulgence.
Of course, and thank you, Your Honor. In connection with the engagement process, I would ask the court to recall that at the suggestion of the Superior Anishinaabe First Nations, Janice Charette, a former clerk of the Privy Council and High Commissioner to the United Kingdom, was retained to act as facilitator in the engagement process and became the mediator in the negotiation process. And of course, Ms. Charette served as clerk, the apex of Canada's more than 330,000 strong public service under the Right Honourable Stephen Harper and the Right Honourable Justin Trudeau. And what could have signified a greater willingness on the part of the Superior Anishinaabe First Nations to engage with the Crown than making that suggestion? And who could have been a more historically significant choice than Ms. Charette? But unfortunately, Ms. Charette's involvement did not cause the Crowns to engage in a more meaningful process. And Your Honor, what we've done overnight is we have prepared what we characterize as an aide-memoire that will take the court and our friends to references to the meeting minutes and to correspondence, but primarily meeting minutes that illustrate the point. And this goes to the question that Your Honor asked Mr. Bass toward the end of the day. But what I take the court to at this point is the minutes of the meeting held on November 19th, 2024. And in particular, you'll see that at the outset of the meeting, Ms. Charette acknowledged the sense of frustration felt in the room at the end of the previous day's session, so that would have been November 18th, and conveyed her willingness to follow the group's guidance for today's agenda. She proposed suspending the planned agenda and adopting a different approach to the discussions in order to essentially recalibrate in view of the frustration in the room. So here we have someone who was brought in to provide guidance to the parties, and early on in her involvement, sensed this frustration that the First Nations had with the process that you've heard about. Each of
could
these—
I see the page reference, please?
Yes.
Can I see the page reference for this?
Yes, of course. We'll take you up to that. And we have hard copy and digital copy of this for each of the parties and, of course, for the court, Your Honor.
And is that compendium, do I have that compendium?
I believe you will have it shortly.
Oh, it's just the record? Okay.
Yes. Each of these is in the record, Your Honor, and I thought that this could be made a lettered exhibit, just to keep track of it, but my friends may have submissions on that point. All of the references are in the record, of course, the existing record.
Thank you. Do you want it made a record? Or sorry, do you want it made an exhibit?
In my submission, it would make sense for it to be a lettered exhibit. And I repeat that each of these items is already in the record, but it would be a concise summary for the court to have on this point.
Exhibit H, would that be right? I. Thank you.
Thank you.
All right, there we have it.
Thank you. And that takes me to an outline of the remaining submissions to be made on behalf of the contingent interest First Nations. And by the way, I expect to be in the range of about 35 minutes in making these submissions. Now, as my colleague, Mr. Bass, noted yesterday, I will address the remaining 4 of the 7 points on which we reply. And they are number 4, the Robinson-Huron Treaty Settlement and the Crown's claims of independence in arriving at numbers for past compensation through the exercise of discretion. The 5th area being the failure to account for the period 2020 to 2024 in setting past compensation, including the failure to account for revenues obtained during that period. The 6th being clarification regarding the availability of charter damages. And the 7th being the contingent interest First Nation share, and in particular, whether it would be appropriate to set an interest rate now in connection with the contingent interest First Nation share. I turn now to the 4th of those 7 points, which addresses the Crown's submissions about the Robinson-Huron Treaty Settlement and their claims that they assessed their exercise of discretion independently. Now, in response to our submissions that there is a reasonable apprehension that Ontario and Canada pegged their exercise of discretion to the Robinson-Huron Treaty Settlement because of the fact that they both somehow arrived at the exact same number, Canada reiterated that they assessed their exercise of discretion, and I quote, independently. But, Your Honor, it's worth noting that both Canada and Ontario came up with 2 numbers, not once but twice, in the engagement process. One for their numbers or their offers on December 20th, 2024, and another for their exercise of discretion on January 27th, 2025. And it is important to remember that both times the 2 emanations of the Crown came up with the exact same numbers. $3 billion on December 20th, 2024, and $3.6 billion on January 27th, 2025. It's also worth noting that Canada and Ontario both came up with the exact same number for legal fees, and that was $20 million each. Now, last Tuesday, for the first time, my friend on behalf of Canada provided an explanation other than coincidence. And she advised this court that Canada told Ontario what its December 20th, 24 offer would be in advance. Now, this is not in the record. It was, in fact, the first time that the Superior Anishinaabe First Nations, the Crown's treaty partner, ever heard this. And it illustrates the Crown's dishonorable and non-transparent approach to the engagement process. And, Your Honor, that is despite the direction, the order from the Supreme Court of Canada telling the Crown to engage honorably and meaningfully with their First Nations treaty partners in the engagement process.
Well, I have a question here,
Yes.
Mr. Gover. My question is, would you have thought it dishonorable if the Crowns had collaborated throughout to come up with joint positions?
I would answer it this way, Your Honor. We would have appreciated knowing what the Crown's methodology was. And questions were repeatedly asked during the engagement process about whether the two emanations of the Crown were going to proceed with matching offers. And we weren't given a straight answer on that issue. So, in my submission, being straight up with your treaty partner is what matters. And in other words, if they were going to proceed in that fashion with matching offers, we should have known it. And it would have had an impact on the manner in which the First Nations conduct themselves during the engagement process. Because certainly, as you'll appreciate, there were issues here as between the Crowns about who derived the revenue from the territory, who was paying the annuity. All of those issues were issues that were of importance in the engagement process. As we looked at net Crown resource-based revenues, as we tried to understand what the 5 factors were, tried to give meaning to what the Supreme Court of Canada said in paragraph 271 of Restool, and tried to understand whether there ought to have been additional factors beyond the 5 factors. And you've heard us on the issue of loss. So yes, it would have made a difference. It would have made a difference to the engagement process. It would have made it more meaningful in my respectful submission. And the court has my point that it's not honorable for the First Nations to learn about this fact for the first time when Canada comes to this court to defend the exercise of its discretion. Canada should have been open with its treaty partners about how it was dealing with Ontario. It could have told all the parties at the same time what its offer was or would be. And instead, the First Nations were left to guess as to how the 2 Crown emanations could possibly come up with the exact same number. And of course, we say now that the 2 Crown emanations engaged in reverse engineering. And the point here really is this does not meet the standard for justification set by the Supreme Court of Canada, that the Crown needed to explain to its treaty partner how it arrived at its number. Now, Your Honor, I'll also add that this is not an explanation for how both Canada and Ontario arrived at the same $3.6 billion figure in their January 27th, 2025 offers. Letters, rather. This is the exercise of discretion, not the offer. They may have also discussed that number in advance. Either way, that does not address our fundamental issue that the number appears to have been pegged to the Robinson-Huron Treaty settlement. Whether Canada and Ontario discussed amongst themselves in advance that they would not provide more than the per capita equivalence of the Robinson-Huron Treaty settlement, or they came to this conclusion independently, does not really matter. Our issue is that it appears to the reasonable observer that they both determined a maximum, a ceiling, in advance. And this raises a legitimate concern that speaks to whether the Crown acted honorably. And that is whether the Crown appears to have acted in good faith in the engagement process. Now, Your Honor, Canada now says that it is, and I'm quote, fortunate to the First Nations, and that is a submission made by Ms. Evans in volume 7 of the transcript, January 11, 2025, page 1183 at lines 1 through 9. So, fortunate to the First Nations that both Canada and Ontario arrived at the same amount of past compensation. But from the standpoint of the Superior Anishinaabe, the Crown's alignment on the amount raises more alarm than confidence. It reinforces the reasonable perception that the engagement process was neither meaningful nor honorable, but a pro forma exercise, and that this was not an independent, good faith exercise of discretion by Canada and Ontario, but rather a meaningless journey toward a preordained ceiling designed to limit liability. And we say with respect, the mere perception of this cannot stand alongside the honor of the Crown. Your Honor, I turn now to Canada's reliance on the Robinson-Huron Treaty settlement as a validation exercise. And in the oral submissions we heard from Canada last week, Canada repeatedly referred to its consideration of the Robinson-Huron Treaty settlement as just that, a validation exercise. Canada maintains that, firstly, it independently, and I quote, determined that honorable compensation for the RST First Nations would be in the range of $2.5 billion. And the reference there is to submissions made on Wednesday, June 11th, volume 7 of the transcript, page 1134, lines 14 through 25. Secondly, Canada maintains that it looked to see, and I quote, how that would compare with other precedents, end quote. Your Honor will recall asking an important question in response to that submission. Your Honor asked if Canada had already conducted a separate independent assessment of what honorable past compensation would require for the Superior Anishinaabe under a sui generis treaty. Why would Canada go looking for precedents? And in response to the court's question, Ms. Evans responded that Canada felt the need to validate its process and consider benchmarks, and that Canada was looking for a way to validate its determination. Your Honor, the First Nations position throughout the entire engagement process and at this review has consistently been that this is not an appropriate validation exercise. A determination of past compensation between two treaty partners cannot be treated as comparable to different arrangements or agreements reached by different treaty partners at different times. The honor of the Crown must be assessed separately in each case. So on this point, we respectfully submit that if Canada had truly assessed the honorableness of its exercise of discretion with respect to the Superior Anishinaabe independently, there would be no need to engage in a further validation exercise to square Canada's exercise of discretion with the precedent set by the Robinson-Huron Treaty settlement. And that's especially given that their treaty partner, the Superior Anishinaabe, have repeatedly asked them not to use the Robinson-Huron Treaty settlement as a comparator or a benchmark. Now, on this fourth point in reply, I also address Canada's urging the court to accept Canada's word. Canada repeatedly relied on the fact that its methodology to assess past compensation has not changed since the outset of the Stage 3 trial. It has done so in an effort to show that Canada determined compensation for the Superior Anishinaabe First Nations and then benchmark that against what was paid to the Huron plaintiffs. In Canada's submissions last week, Ms. Evans conceded that she cannot prove that that was, this is somewhat awkward in a turn of phrase, chronologically what happened. The reference there is volume 7, June 11, page 1141, lines 1 through 13. On behalf of Canada, Ms. Evans told Your Honor that you would simply have to accept Canada's word for this. And that is volume 7, it's Wednesday, June 11, once again, page 141, lines 9 through 12. Now, Your Honor, that submission sits uncomfortably with the Supreme Court of Canada's statement that the Crown has lost the moral authority to simply say, trust us, as the court said in Restool at paragraph 262. Telling this court and the Superior Anishinaabe to take Canada's word that Canada did not peg compensation for the Superior Anishinaabe to the Huron settlement does not meet the justificatory standard, the justificatory burden to explain Canada's reliance on the Robinson-Huron Treaty settlement or help restore the honor of the Crown. And now I turn to our fifth point in reply, the Crown's failure to adequately compensate for the period 2020 to 2024. And here the focus is on Ontario. Ontario concedes that in exercising the Crown's discretion in relation to past compensation, its minister did not provide additional amounts for 2020 to 2024. But Ontario has still not provided any reasoned explanation for its complete failure to do so, claiming to have compensated the First Nations up to the present while relying solely on evidence that does not extend beyond 2019. Ontario's submissions to Your Honor do not substantively respond to this argument. Ontario says that the review of the Crown's exercise of discretion must be conducted holistically and not considering elements in isolation. But resort to words like holistic provide no cover for the Crown in this circumstance. Ontario points to the concessions it made to increase its calculation of net benefits from $375 million to $2.7 billion, wiping all negative years from 1945 onwards to the advantage of the First Nations. Essentially, what Ontario does is this. It appears now to be arguing that it was so generous to the First Nations that it can just ignore revenues from 2020 to 2024. But there are two problems with that explanation. First, that explanation appears nowhere in Ontario's January 27th, 2025 explanation letter as the rationale, and therefore contradicts Ontario's supposed reasons first approach to this review. And secondly, this argument overlooks the fact that the Supreme Court of Canada ordered the Crown to exercise its discretion and determine an amount to compensate for past breaches up to 2019. And that would necessarily require Ontario to make concessions that would increase the shareable wealth from the treaty territory to minus 4.6 billion, which was Ontario's position at the end of the Stage 3 trial, to some positive figure. These concessions made by Ontario offer no explanation as to why Ontario determined it would be reasonable to offer no additional compensation for the period from 2020 to the present. If there was shareable wealth for this period, the First Nation should not be completely deprived of any benefit from the treaty promise for that period. And Your Honor, this is not a line-by-line treasure hunt for error as Mr. Rankin suggests. This is a complete absence of justification on a disputed point between Ontario and its treaty partner. And we say with respect, Ontario's blatant regard of this issue is unprincipled, unreasonable, and dishonorable. Your Honor, the sixth of our 7 points in reply involves clarification of the availability of charter damages. And here I will be brief in making the point. This is in response to Canada's submissions on the availability of charter damages made on Wednesday of last week. Canada's submissions in response to questions from the court seem to suggest that the Supreme Court of Canada held in Ward, that's W-A-R-D, that as long as another form of compensation is available, such as tort damages, charter damages are completely unavailable. And here the transcript reference is at volume 7, page 1127, lines 12 through 15. And
Sorry, what was the page reference, please?
the page is 1127, and the line reference is 12 to 15, and it's volume 7. And at this point, Your Honor, I'll ask Ms. Angelova to display paragraph 34 of the Ward case. And here you'll see the court states a functional approach to damages under section 24(1) means that if other remedies adequately meet the need for compensation, vindication, and/or deterrence, further award of damages under section 24(1) would serve no function and would not be appropriate and just. Continues, the charter entered an existent remedial arena which already housed tools to correct violative state conduct. Section 24(1) operates concurrently with and does not replace these areas of law. Alternative remedies include private law remedies for actions for personal injury, other charter remedies like declarations under section 24(1), and remedies for actions covered by legislation permitting proceedings against the Crown. Important words, though, are if other remedies adequately meet the need for compensation, vindication, and/or deterrence. A further award would serve no purpose. So you have my point here. The Supreme Court of Canada is clear that charter damages operate concurrently with and do not replace alternative remedies. Further, the court will refuse to order charter remedies where we're dealing with violative state conduct. Only if the alternative remedy adequately achieves, I return to those words, compensation, vindication, and deterrence. It comes back in my submission to the fundamental question in this case: is the amount of compensation that the Crown has provided sufficient to compensate the Superior Anishinaabe, vindicate their rights, and deter the Crown from future breaches? And we submit that it is not sufficient to achieve those purposes, and therefore the amount of compensation must be increased. And finally, I turn to our 7th point in reply, the question of whether the interest rate applicable to the contingent interest First Nation share should be set now. Canada, in its submissions, argued that the interest rate should not be set now to allow for flexibility. And essentially, Canada argued that when it comes to what is in the contingent interest First Nations' best interests, Canada knows better than the contingent interest First Nations do themselves. Your Honor, in my respectful submission, Canada's submissions here smack of paternalism. We accept that trade-offs exist between the values of flexibility and certainty But our clients believe that certainty is more important in these circumstances. They believe that for the reasons I explained 2 weeks ago and will not repeat now. Canada also said that their approach was consistent with the Anishinaabe principle of renewal. Well, it is not renewal to consign the parties to potentially 6 separate new trials on the issue of the interest rate in the future. Creating, prolonging, or deferring a contentious interest among the parties that they have not been able to resolve yet is not what renewal is about. This is a perpetual treaty that will require the parties to continue to work together and renew the relationship well into the future as they discuss future annuities. So we do not need to leave the interest rate issue on the table to ensure that they continue to discuss it in the future. And in fact, in our submission, it would be more conducive to a productive relationship to resolve the issue now, to allow the parties to move forward in their relationship, to stop arguing about the past, and then to move on to other issues that can and should be resolved.
Mr. Gover, I have a question here. Do you say the court needs any particular authority? I am referencing Ontario's submissions with respect to Courts of Justice Act on pre and post judgment interest and how neither apply. Do you say, what do you say about authority?
I say 2 things. First of all, the court's inherent authority is a basis in the circumstances of this sui generis review. But secondly, I say that the Supreme Court of Canada has given a broad mandate to the court here to effect justice that has been long delayed. And in my submission, provided that it is not inconsistent with the provisions of the Courts of Justice Act in any way that could have been foreseen by the Supreme Court of Canada, then in my submission, the court has the jurisdiction to do precisely as I've said and to fix the interest rate in the manner that we've described.
Thank you.
Thank you. Your Honor, I close with this. At the end of the day, the Crown was given an historic opportunity to make things right with its treaty partner, to repair a breach that stretched across generations and became a national disgrace. But instead of honoring that moment, the Crown turned the Supreme Court of Canada's direction into a process that was opaque, outcome-driven, and fundamentally disconnected from the constitutional standard that it was meant to uphold. Both the process and the outcome fall short. The Crown has not restored its honor. Instead, it has compounded the breach. And that is why we are here. Because when the honor of the Crown is left wanting, it falls to the court to set it right, as this court was mandated to do by the Supreme Court of Canada in Restool, which takes us back to where we began this morning in paragraph 310 of the decision. And so on behalf of our clients, we respectfully ask this court to do just that, to step in, to intervene, and to set the amount for past compensation, an amount that is just, liberal, and honorable. And subject to any questions, Your Honor, that would conclude the submissions on behalf of the contingent interest First Nations. And I note that it's 10:40 a.m., precisely where I predicted.
Thank you very much. I'm sure there are points somewhere for that.
Thank you, Your Honor. Have a good morning.
Okay. I see a compendium from the plaintiff's reply. Shall we make that an exhibit J?
Yes, it would be Exhibit J if we could, please. For the monitor, my name is Harley Schacter. I appear with Caitlin Lewis on behalf of the representative plaintiffs, Whitesand and Red Rock First Nations. I've handed up the compendium. We've marked it Exhibit J. I would advise the court that at tab 1 of the reply compendium we've just handed up is an outline of the subject headings that I was planning to speak to in response to the Crown's oral submissions. You'll see as we go through it that I've been knocked off that agenda because a lot has already been covered, and I'm hoping not to repeat, my friends. What you should have before you for my reply is not only my oral reply compendium, but also my earlier compendium Exhibit A of June 2nd, 2025. I believe I will have occasion to refer to that.
I've got it. Thank you.
Now, I just said that there's much in the compendium that I do not expect to go to, and for these two reasons, because much of what's in the compendium is really backup in case the court wants to view the actual transcripts or cases where I am going to be summarizing the matter in my presentation. And of course, yesterday and today, much of what I was going to cover has been covered, and I'm trying to delete repetition.
Thank you.
What I would say is that we adopt what was said by my colleagues and friends in oral reply, and we continue to rely on our written reply, which we do not propose to get into right now. Now, before dealing with my issues in my outline, I wanted to address two questions that the court had yesterday and one question the court had today. Starting with the one today, when the court asked Mr. Gover, would it have been honorable if they would have come up with a joint approach? The answer is no, that still wouldn't be honorable, because the problem is they should include us. It should be a three-way engagement, not a two-way engagement. Had they come up jointly and come up with a position that would have made a difference, and indeed, one of the early issues that the RST Anishinaabe identified is the need for a joint Crown approach in the event there could not be a consensus. And that was a feature of the proposed agreement that we had put forward to the Crowns on October 7th, 2024. It's at tab 414. Sorry, my tabs, we ran out of tabs, so all my tabs are 1 to 10. Tab 14 of the
Oh, but I was able to get.
Yes, there was one set of good tabs, and it wasn't me who should get the right ones. In any event, what I wanted to address was just this. I
Okay,
think-
so I'm at tab 14.
Yeah, tab 14, on the bottom right-hand page, you'll see the compendium page numbers.
Yes.
And so if you go to page 114 of the compendium, which is record page 1321. And at the bottom, what we were trying to do here was to figure out a collaborative process for both the engagement and the decision-making process. And the idea was, let's try and agree. It's a nation-to-nation relationship. Let's try and agree on what the engagement process is supposed to look like and how we will jointly arrive at a process. And we were even prepared by the time October 7th came around to appreciate, you know what, maybe there will not be a consensus reached on all matters. But if there isn't, the Crowns are going to have a position. But we realized, and if you'll see it, paragraph 9, one of the engagement process details that we thought was important was that the Crowns had to act together. So from paragraphs 9A and following, we said the Crowns have to agree on how the engagement process is going to look. And that makes sense because there really can only be one way to know what the treaty obligations are. And we said the same thing in terms of the decision-making criteria, starting at paragraph 13 of that proposed agreement at compendium page 116, record page 1323.
So it's possible I misunderstood your opening proposition here. You say, in answer to the question I asked, you say, no, it would not have been honorable if they had come up with a joint approach. It should have been a three-way.
That's the answer to the question of whether it's honorable or not.
Yes.
But in terms of working together, that could be the only response to a decision. The decision could only be a single decision. That's a different issue, but I took you to that. Now, the second issue I wanted to talk about was the question you asked towards the end of the day, which the Anishinaabe being deprived of the relational aspect of the treaty. Mr. Gover has taken you to pretty much everything, but I wanted to take you to and remind the court, again, dealing with the relational aspect that we were deprived of very early on in the process. And I'm going to take you to tab 7 of our reply compendium. This is August 19th, 2024. A letter to myself, from myself. Yeah, from myself.
Did you say which tab?
Tab 7. Yes.
Got it. Thank you.
Tab 7, August 19th, 2024. A letter from myself to the Crowns on behalf of the First Nations. And if you look over at compendium page 59 at the bottom, what the Anishinaabe said was so important: transparent, predictable, and rational process. That's what was so important. And if you go over on the next page, page 60, record page 1157, you'll see in the second paragraph, we seek the Crown's agreement that transparency and predictability in this context are not merely procedural niceties, but they are fundamental to upholding the Crown's honor and demonstrating respect for their treaty partners. Put another way, if the rules of the game are improvised during the process or are identified only after a decision is made, the decision cannot be said to be a rational one. We hope you will agree that rational decision-making is a core precept of the Crown's duty to diligently fulfill the augmentation promise. We then say in in the next paragraph, rational decision-making is defined not only by adherence to a fair and transparent process, but also by a logical, data-driven manner of following the steps to that process. Rational decision-making requires that all relevant factors, as well as the method by which those factors will be weighed, be identified and communicated before any decision is finalized. And we said this clarity ensures that decisions are made on a sound and principled basis rather than being retroactively justified after the fact. And at the bottom of this page, last paragraph, without jointly agreeing upon the engagement process and the key decision-making criteria that will inform the exercise of Crown's discretion, the nation-to-nation relationship of equals envisioned by the Supreme Court of Canada will be seen little more than window dressing, and the Nishnaabeg principles of respect, renewal, reciprocity, and responsibility would be relegated to the scrap heap. Now, the letter goes on the very next page to reiterate similar concerns, but the point is, it's not just as we were in the engagement sessions that the problems about ignoring the relational aspect started. It started very early on, and we identified it as a core issue, a core way of proceeding that the Anishinaabe thought would respect the relationship, and that never happened. The second thing, sorry, unless there's any questions, I'm going to go on to the second question from yesterday. The second question yesterday was the court's reference to paragraph 308 and the degree of deference to be afforded to the Crown. Now, later on today, I will return to the degree of deference in response to the Crown submissions, but I wanted to address the court's question on this right now. Ultimately, at the end of the day, constitutional compliance is for the court to decide upon. And it cannot be constitutionally compliant if either the engagement process or the outcome does not meet the bar. A bar set by the court that is consistent with the treaty obligation and consistent with the honor of the Crown. Now, in considering whether the engagement process or the past compensation meets that bar, we agree and accept that the court must pay careful attention to the Crown's explanations. Now, where those explanations involve reliance on polycentric considerations, where the Crown might claim to have expertise, a careful consideration may require the court to give a degree of deference. But the court still has to ask this question. What is the specific issue or consideration that the Crown turned its mind to in respect of a polycentric consideration for which it is claiming deference is due? And secondly, where is the evidence that the Crown has offered to allow the court to consider whether that deference is justified? The problem that both Crowns have in the review portion of these proceedings is that they have claimed the existence of important polycentric considerations, but they have not provided any evidentiary basis or any reasoned explanation to support that deference is warranted. Now,
Can you give me that proposition again?
Yes.
They have claimed?
they have claimed the existence of important polycentric considerations.
Existence of.
Yes, of important polycentric considerations, but they have not provided any evidentiary basis or good reasons to support that deference is warranted. And we encourage, and obviously the Supreme Court of Canada said, pay close attention to what they say in their reasons. But you won't find a justification. You'll find, as I think someone claimed, cloaked in a cloak of polycentric considerations, as though it's some sort of magical incantation. Now, the Supreme Court of Canada, of course, says pay close attention to the reasons in this regard. Now, other than claiming that parity on a proportional population-based basis with the Huron settlement is a relevant polycentric consideration, when you look through the reasons, there's 3 possible polycentric considerations that are raised by the Crown, and only 3. 1, the needs of the RST Anishinaabe. 2, the fiscal capacity of the Crown to make payment. And 3, the needs of others.
What was 2?
2 is the fiscal capacity of the Crown to make payment.
Thank you.
In respect of the first criteria, the needs of the RST Anishinaabe, the evidence from stage 3 that the ministers had to go on, which was not challenged and was actually confirmed by some of the other information that came out of the engagement session, was that more than 100% of the Crown benefits captured over the years would not address all the Anishinaabe needs. So any polycentric consideration would not temper down what should be paid, it would temper it up. With respect to the second criteria, that of fiscal capacity, both Crowns have insisted that they do not lack the fiscal capacity to make payment. And the Supreme Court of Canada at paragraph 295 says, because of the egregious breach, the amount will be substantial, and that's the Supreme Court of Canada's words, and that the Anishinaabe cannot be shortchanged in 2025 because of the Crown's sticker shock. It is really the third factor, the needs of others, where polycentric considerations might indeed fairly rear their heads. But what is lacking in the Crown's decision letters is an explanation as to how the needs of others would be impacted by due performance of the treaty obligation to share the wealth where there is wealth to be shared. What is lacking is the Crown's explanation is what the needs of others was in the past that might have affected the share in the past, or why the needs of others, other Canadians in 2025 results in a past compensation amount of $3.6 billion. There is no justification for this. There is justification offered that the amount being claimed needs to be balanced against immediate problems suddenly facing the Canadian economy, largely because of tariffs. You might recall my friend from Canada referred to the fiscal update from 2024. Now, respectfully, in any one year, that might be a justification for a deferral of a payment otherwise to be made. But it is not justification sitting in 2025 for non-payment of what has become due over 175 years. And it is no justification to ignore compensation for the harms caused by the loss, as Ontario does. Now, in the engagement process, the RST Anishinaabe thought that the Crowns might raise such an issue of fiscal capacity at any particular time and proposed that in times of need of others, there could be a deferral to times of plenty. And rather than just simply assert that, we actually retained Mr. Hutchings and provided economic evidence brought forward in the engagement session that was not disputed by the Crowns, which, to summarize, save for a few $100 million since 2008, it is true that over the last 175 years, all the monies claimed, even the maximum amount on Stiglitz and Hutchings analysis, and even brought forward at the highest bring forward rate, if they were not paid diligently when they should have been paid in any one year due to deficit, or I would say due to its times of war, it's a depression, we need to readjust our priorities. All of that could have been made up in times of plenty. So if there were polycentric considerations in the past, they could have been addressed. And you'll find, if you want to look at it, in our original compendium at tab, I'm not going to turn it up, in our original compendium at tab 11, at page 125 and at record page 2712, you will find Mr. Hutchings' report, expert report, and on this issue. And the Crowns simply ignored that evidence. So what is lacking is the Crown's justification. There is lots of data over the past 175 years that was available to the Crowns over the 6-month engagement period. And they had a roster of many economists, many historians to draw upon to justify any polycentric considerations in the past or any current polycentric considerations, and to genuinely explain to their treaty partner and to the court why they couldn't pay now what is owed and what their plan was because of their current polycentric difficulties. There is no evidence that the needs of others in the past would have been affected by the Crown sharing in the past some portion of the nominal net benefits the Crown received had they diligently implemented that in the past. Remember, the numbers were relatively small. And remember, the number we're talking about represents a very small proportion of the overall fiscal capacity or fiscal receipts, reducing down to, I think, somewhat less than 1% at the current time. There's also no compellable evidence that the needs of others would be affected in 2025 by the sharing today. Now, Canada and Ontario point to gloom and doom today based on Canada's fall fiscal statement. And it is perhaps, I think, worthwhile to look at that statement and one important observation contained within the fall fiscal update, which is record page 120, and I want to go to record page 121. It's not part of my compendium, which was being prepared before, but I believe Ms. Lewis is going to put it up on the board, on the monitor. You'll see that this fall fiscal statement quotes from the Parliamentary Budget Officer on August 28th, 2024, current fiscal policy at the federal level is sustainable over the long term. We estimate that the federal government could permanently increase spending or reduce taxes by 1.5% of GDP, $46 billion in current dollars, growing in line with GDP after, while maintaining fiscal sustainability. Our assessment reflects all budget 2024 measures. Now, that's 46 billion in current dollars per year from the federal government. That's not even talking about Ontario. Now, that's within the fall fiscal statement that my friends cite for gloom and doom. But what's important about that measure is if you go to record page 2021, and here you have to go to my original compendium tab 16. It's compendium page 160. So compendium page 160, record page 2021, at the top of the page, you will find that the Anishinaabe pointed this very provision out to the Crowns and said, look, you've got fiscal sustainability. You've got the ability to make a large payment. We went on in the very next paragraph to express concerns that the provincial government identified $3 billion available as a giveaway to taxpayers without engaging with the Anishinaabe on that issue. I mean, if it's an important polycentric consideration, where was Ontario at the table saying, you know, we really need to give each Ontarian $200 or $300, whatever it was? Where was that? That's not engagement. And the third paragraph is we also attached the finance minister's document released on or about October 30th entitled Building a Better Ontario 2024 Ontario Budget. This document suggests no shortage of monies with which to honor an annuity payment. And by that, I mean the kind of annuity payment that the Anishinaabe were seeking and continue to seek. So what did the Crowns do with that in the engagement session? Nothing. So yes, a degree of deference to polycentric considerations may be warranted, but surely there must be justification before there can be deference. And this has not been demonstrated. That concludes my answer to the question that you raised yesterday.
Thank you.
Moving to my outline of lens. I thought one of the things that it occurred to me is that implementing the treaty through an incorrect lens is fundamentally an error of law, is incorrect, is unreasonable. Any standard, it doesn't fly. Now, my colleagues took you to a significant number of instances where the Crowns fundamentally misunderstood what the treaty requires of them. I will not be repeating that at all. I take it you have their points, but my point is, if you go into the engagement sessions believing that your obligations under the treaty are X, Y, and Z, and it's much more than that, the output cannot be sustained. You've turned your mind to the wrong principles, and the Crowns looked at the treaty through the wrong lens and continue to do so. I want to only address a couple of them that came up in the Crown's oral reply. The first, one being about the Huron settlement. I think my friends identified the Huron settlement as a floor? No.
Which friends?
Sorry, Ontario. My friends of Ontario identified the Huron settlement as being a floor, not a ceiling. No, it was a ceiling, not a floor. Both Canada and Ontario in oral submissions claimed that they entered into the engagement session with an open mind about the Huron settlement. Ontario put forward that the relative parity with the Hurons was a floor, not a ceiling. But I want to take you, please, to my reply compendium tab 5, which is part of Ontario's reasons. And at paragraph 6 of those reasons, we're looking at compendium page 55, reply compendium page 55, paragraph 6 of the Minister of Ontario's reasons. And what the minister says in talking about the Huron settlement is the Supreme Court ordered the Crown to negotiate honorably and meaningfully with RSFN based on the correct interpretation of the augmentation clause as a reviewable discretion in the context where the Crown had entered into a historic agreement with RHFN prior to the Supreme Court clarifying the interpretation of the treaty. Ontario understands this to be an invitation for the RSFN, Ontario and Canada, to attempt to reach a resolution comparable in broad sense to the RHT settlement. Now, here's a fatal mistake. Although they told you that they had kept an open mind, they approached the whole process with the wrong. I'm going to submit that the Supreme Court of Canada did not say that you should attempt to reach a resolution comparable to the RHT settlement. Plain out, they didn't say that. But that's the lens that Ontario brought to the table. Over on the next page of the compendium, at paragraph 16 of the minister's reasons, you will find this statement. The second line of 16, referring to the 3.6 billion. The 3.6 billion is, and now in quotations, consistent with the benchmark provided by the RHT settlement, which was inclusive of legal costs. And then in the middle of the paragraph, it is just, honorable, and fair for Ontario to treat the RSFN in a broadly comparable manner to the RHFN. Well, there you have, in a nutshell, those two paragraphs explaining, I don't want to call it a predetermination. I think others have. I'll call it a wrong lens. And that is being charitable. Canada, for its part in oral argument on June 10th, 2025, transcript page 1040, I'm not going to take you there, likewise succinctly summarized Canada's view that Canada determines that the amount of compensation should not be substantially different on a per capita basis as the RHT. Respectfully, this fixation on a settlement amount that is untethered to the obligation of identifying an amount of past compensation for an egregious breach going over 150 years, that was not even admitted in 2023 when the Huron settlement was made, taints the whole process. Now, at this stage, I want to digress very briefly on to my second point, which has to, because it deals with the information available about the Huron settlement and whether there should be an adverse inference drawn. I think in their oral presentation, Ontario has misunderstood my concerns over the Crown's refusal to provide details concerning the Huron settlement. Now, those details, if they were provided, may have allowed the RST and the court to consider whether there was indeed any basis to claim parity. We don't know. Ontario and Canada assert that the facts that the minister considered in respect of the Huron settlement are part of the record. And they say it was confined to three things and three things only: the absolute amount of the settlement, the relative populations of each group, and the relative productivity over time of each treaty territory. But our point is that these three elements tell the minister nothing logically probative of a just and liberal and generous and substantial past compensation payment owing as a matter of law and as per a judgment of the Supreme Court of Canada. We say putting those three elements was not enough. The issue is what should have been put before the minister to allow for a meaningful comparison. What is missing from the minister's reliance on parity is how and why the 10 billion was arrived at and why the Crown understood, if at all, that the Huron settlement was honorable, and critically, why the Crown would have believed or would have understood that the amount of the Huron settlement would have been just, honorable, and generous, not in 2023 when times were different, but would have been just, honorable, and generous in 2025 had the Hurons not settled. Now, failing to consider all the relevant facts that should have been considered by a decision maker is an error of law. And under any standard of review makes the decision unsustainable. Returning back to lens, I could stop now. It's a relatively decent place to stop if you'd like and take a break.
I'm good to go for, we go for 10 minutes?
Yes, absolutely. Returning to the issue of lens and some of the fundamental errors that the Crown's in oral argument showed. Ontario says that our approach to quantifying losses is bad because it rests on the assumption that there should have been augmentations made in the past. And you'll find that at transcript page 1276. I don't intend to ask you to turn it up, but my quote I have in my little notes here: we are wrong, they say, because our approach to quantification, and now in quotation marks, rests on the proposition that there are augmentations that would have or should have been made in the past. Now, this court does not need to accept the proposition that there should have been augmentations in the past. the Supreme Court of Canada has already expressly affirmed that there should have been augmentations in the past. And I'll just refer you to the Restool decision at paragraph 10, 11, 284, and 289. Now, for Ontario to come away from a reading of the whole of the Supreme Court of Canada decision that their breach was simply failing to turn their mind to whether there would be an increase demonstrates how seriously Ontario has misconceived what its constitutional duties are. Next, lens. A lens relating to the form, level, and aim of the sharing that the augmentation clause requires. Both Crowns assert and base their approaches to compensation and engagement on the idea that the form, level, and aim of the sharing that the augmentation clause requires is not part of the scope of the treaty right, but is a matter of Crown discretion, which quite frankly, neither Crown actually explains in any detail, even if they did have the discretion to decide what the augmentation clause requires. And here, I want to point out what is, to me, obvious. It is not, if you actually read the sentence, it says the form, level, and aim of the sharing that the augmentation clause requires. If the augmentation clause requires something to happen, this is a feature of the interpretation of the treaty. It is not part of Crown discretion. As for Ontario's new theory, as far as I can understand, advanced in oral argument for the first time, that paragraph 180 of the Supreme Court of Canada is prospective only, their reasoning offered up as to why this is the case does not withstand scrutiny. Now, they make this allegation, or this, sorry, not an allegation, they make this argument at record page 1282. Sorry, I'm going to correct myself. That's transcript page 1282. I apologize. Which is in my reply compendium, tab 4. Tab 2 is all the excerpts I'm referring to from June 10. Tab 3 is from June 11, and tab 4 is the transcript references from June 12th. So at transcript page 1282, the rationale given as to why the form, level, and aim interpretation is only prospective is that, and now in quotation marks, it makes sense that the court might determine the level of sharing in a future augmentation, because if the parties can't agree in a particular future augmentation, then the Crown decides, and it might then go to the court on review. Well, respectfully, that's exactly where we're at right now. The Crown, we weren't able to agree. The Crown has made its discretionary determination, and we are before the court on the review. There is nothing in that argument that suggests that the matter is simply prospective. And I might add that in terms of institutional memory here about this case, I wonder if you could go to tab 9. Now, before the Supreme Court of Canada decision was rendered, And as we were approaching stage 3, what? Sorry. Ms. Lewis has pointed out that during the stage 3 trial process,
I'm recognizing that document as something that
yes,
possibly that I asked for.
yes. Okay, this is in June of 2023.
The end of stage 3.
Yes. But long before the Supreme Court of Canada rendered its decision, the court had asked the parties, well, what are the issues that are needed to be decided in order for this court to deal with past compensation? And indeed, Ontario put in at paragraph 1E, what is the form, level, and aim of the sharing under the augmentation clause? They knew and understood back in 2023 that the form, level, and aim of the sharing that the augmentation clause required was a matter of interpretation that still hadn't been decided yet.
This is an Ontario document?
Yes. If there's any question about it, it did come with an email cover page from Ontario Council.
Thank you.
Next, continuing on with lens, I've skipped over, it looks like 5 different lenses that my colleagues have already covered. The lens of what the treaty bargain is. The plaintiffs say that the Supreme Court of Canada was clear that the treaty bargain is about sharing the wealth where there is wealth to be shared so that both parties could thrive in a familial web of respect, responsibility, renewal, and reciprocity. Ontario's lens, and you can see this at their transcript page 1355, which again, you don't have to turn it up, part of reply compendium tab 4. Ontario's lens is that the core of the bargain is the Crown's exercise of discretion. We say that that's a wrong lens. They get off to the wrong start.
The core of
the bargain. We say the core of the bargain, what we're trying to do is share the wealth where there's wealth to be shared. And the benefit of the bargain that Ontario recognizes is the bargain of the Crown's exercise of discretion. It's the wrong lens. Now, next lens, failing to grapple with the nominal net resource revenues. Respectfully, at transcript page 953, which is found at reply compendium tab 2 on Canada in oral presentation, argued before you that the only basis of shared comparison was at bond rates. So they use bond rates. Respectfully, that is willful blindness. Meanwhile, Ontario's assertion that nominals don't tell you anything meaningful is unfair and incorrect. And they made that assertion in transcript 1561 to 1562 at reply compendium tab 4. Fact of the matter is, either Crown could have and should have presented data not only at bond rates, but at nominal and other bring forward rates so that a true and genuine range of compensation could be discussed in dialogue with the Anishinaabe. The nominal comparisons in any year are important, because it tells the reader truly how far apart Bodway and Smart continue to be from Hutchins. At record page 2727 in our original compendium, tab 11, page 140 of that first compendium, that is where you will find that on a nominal basis, even after all of Ontario's adjustments, we're talking about $20 million for Ontario over 175 years and 1.043 billion for Hutchins over 175 years at nominal rates. Now, when Canada says we should prefer Hutchins more than Bodway and Smart, yeah, okay. If that's going to be a dialogue about trying to choose a number between there, then you would be looking at somewhere between 20 million and 1 billion. And if you were going to go closer to Hutchins, that's a very different kind of principled approach than masking the task by burying it in bond rates. Because if you do it only in bond rates, you mask the great difference. 2.7 billion to some other to 11 billion or 9 billion at bond rates doesn't seem like such a huge difference, but if you actually look at the effect of the bond rate being baked in, you see the insidiousness of the approach that the Crowns chose to bury it. Now, when Ontario stood up in argument and advanced the proposition that the $3.6 billion amount falls within a range of Hutchins BTA calculations, it wasn't wrong for them to have in mind ranges. But firstly, the ranges they identified was Hutchins NCRRs only up to 1945. Now, the court asked Ontario Council if they could advise what Hutchins bond rate calculations were using Hutchins NCRR data. Ontario was unable to tell you, but we told Ontario in the engagement process, and we will direct you to that evidence now. It is found in record page 3546. It's tab 55C of the record. It is helpfully contained in the reply compendium at tab 11. Okay. All right, I'm sorry, I have identified it the wrong, my note is wrong here. Those are nominal tables. Sorry, Ms. Lewis, do you want to explain? Because I don't know the point you're making. You want to stand up and make your point? All right, I apparently have confused that the nominal tables are at June 2nd. June 2nd compendium, page 153 and 154. So let's turn those up for a moment and maybe I can get back on track. All right, so at those tabs 14 and 15, we have the nominal numbers for the full 175 years for Bodway and Smart and for Hutchins. And the point I was going to would be, if you look at tab 11 of the reply, our oral reply compendium, you will see record page 3546, which I understand to be tab 55C of the record. It's in our reply compendium, and the answer to the question that you had asked Ontario, at long-term bond rates, how much are Hutchings NCRRs? They are indeed, if you look on the top right-hand side, $9.434 billion at bond rates. And of course, this chart, which was shared with Canada during the engagement session, demonstrates substantially more at different bring forward rates.
Have we hit a good time for a break?
Maybe I should just finish this one last point.
Okay.
And indeed, I have finished it. Okay, now would be a good time for a break.
All right. I would like to see counsel in the room, please.
Court is in recess until recalled. Court is resumed. You may be seated.
Afternoon, good morning still. I continue with my lens analysis, and then there's a couple more points I want to make on the error in the lens and the error in the approach. At the transcript 1285 to 1288, which is in the compendium, I believe at tab 4, Ontario commits, I say, a fundamental error in reasoning path and analysis when it rejects the approach of a data-driven outcome to provide a guiding range on what I say is a straw man argument that our approach is a mathematical one that leads to a specific number and thus offends the ruling that the Anishinaabe were not promised a fixed number. We agree that the treaty doesn't provide us with a fixed number, and on June 12th, at transcript pages 1273 to 1274, Your Honor correctly captured the purpose of the various computations. It's not for the purpose of trying to convince the court or anyone that there is one correct mathematical results, which admits of only 1% share in every year. Rather, that data looked at from multiple scenarios paints a picture so that the reader or the court can do an assessment of an appropriate range. That's what I have to say about lenses. I was going to turn to there's only one treaty and the problem with multiple treaty interpretations and implementation. We've already dealt, I think, with that, and my friends have as well. I want to turn to responding to Canada's population-based share very quickly. On June 10th, Canada at transcript page 1023, which would, I believe, be in tab 2 of the reply compendium, Canada puts reliance on Minson or Ryden, who they say came up with the population-based share. Now, keep in mind that Minson or Ryden also gave evidence that a 50-50 approach was possible. Now, Canada says it was reasonable for us to adopt the Minson and Ryden population-based approach. And you might recall that that was based on the breakup of Czechoslovakia. But what was divided in Czechoslovakia was not dividing up only about 1% to 30% of a portion of the crown's wealth, but what was shared was dividing up all crown assets. The analogy in this case would only make sense if the crown were dividing up administration and control of the whole of the Robinson Superior Treaty Territory among two nations to create two different independent nations on a go-forward basis. And if all crown wealth, not just some of it, not just 2% of it, not just 30% of it, if it was all on the table. And assessing past compensation for treaty breach, in this case, has no comparison at all to the breakup of Czechoslovakia. Stiglitz and Hutchings dealt with this in their reply report, stage 3, trial exhibit 4, paragraph 90 and following. Turning now to the Crown's concessions were illusory. First point, on June 12th, 2025, I believe that's the time, at transcript page 1200, Canada, I might have the date wrong there. It's transcript page 1200. Canada supposed that liberality in paying 50% instead of 20% is them, the Crown, Canada being liberal. Respectfully, it might have been liberal towards Ontario to do that, but it certainly was not liberal or a concession for the Anishinaabe. Next, turning to illusory compromises. Consistent approaches are not presumptively honorable ones. Counsel for Canada urged the court on June 10th, transcript pages 1018 to 1019, which are at reply compendium 2, that their approach has always been consistent. And I am paraphrasing, has always been consistent, and that as a result, the court should take away that a consistent approach must be an honorable one. But we say a consistent approach does not prove that the approach is honorable, only that it is consistent across time and hasn't changed. Now, obviously, refusing to change one's approach or position even as the facts change is also a sign of unwillingness to hear, unwillingness to listen, and unwillingness to compromise. Now, Canada may indeed have made an offer of $2.5 billion before stage 3, as my friend pointed out. They may have made a $2.45 billion offer after stage 3, at the end in argument at stage 3. They may have made a $3 billion offer on December 20th and a $3.6 billion determination on January 27th, 2025. But all that consistency could simply be telling us is that Canada has been consistently dishonorable, or it can tell us that Canada has had its feet cemented to the floor. Another way to look at Canada's consistency is to say that nothing that happened since the beginning of stage 3, nothing that happened before the Supreme Court of Canada, nothing that happened in the engagement session caused them to rethink their approach or fundamentally their result. This unwillingness to change or resistance to change is telling, especially for anyone who sat through the stage 3 trial process.
Do you say by chance that there are two things that are linked? One, consistent numbers from a certain time, and the RHT deal that Canada entered into?
I'm not sure I understand the question. I mean, certainly Canada, the point Canada was making is we've been consistent in our approach, and that drove to the same number. Now, I'm not sure I understand the question about how the RHT settlement figures in. Perhaps if the court could ask me again, I'll try and get it.
I'm
understand.
just figuring out the concept, so let me try it again.
Yeah.
Do you see a link between the consistency of Canada's approach and the fact that during those time periods that you mentioned, pre-stage 3, which is when the RHT deal was made,
Yeah.
pre-stage 3, post-stage 3, post-SCC, post-engagement process, do you see a link between the consistency of that approach and the reliance on, I don't want to say reliance, that's not their word, and the link and the comparability to the RHT?
I think one can draw that conclusion that throughout the process, there was this linkage. From beginning to end, that linkage never ended. And that's why I started my presentation on Lens on that very issue of how they approach the engagement and approach their decision-making. The focus was on the Huron settlement as a ceiling. And so, yes, obviously we can't know for sure, and the court doesn't have evidence before it about what happened pre-stage 3 about a $2.5 billion settlement offer, other than it had been made. But one can fairly guess fairly come to the conclusion that the linkage was always there with the Huron settlement or the Huron negotiations. I wouldn't want to push it too far in terms of the linkage at times when there isn't any evidence about, but we do know that the linkage is there during the engagement session, right? And that they entered the engagement session with that linkage in mind. The next issue of concessions is that last minute, relatively illusory concessions do not advance reconciliation. Now, in oral argument, Ontario told you that the minister made a concession on January 15, 2025, relating to indirect capture in person. That's at transcript page 1491. And I believe another Ontario counsel said it was a big deal at transcript page 1511. Now, firstly, it is not a big concession or a concession at all when one concedes that there is indirect capture over and above NCRRs. All experts actually agreed that there was. It was a question of how to quantify it. Secondly, on January 15th, there was no concession. All there was that the minister would consider it. And on this, I would turn to reply compendium. I'm just going to try and find it. Tab 16. These are minutes of the meeting held on January 15, so shortly before the determinations were made. And the minister, it says, Minister Rickford briefly addressed indirect benefits, commenting that this would be an area that Ontario was prepared to consider, and it would be useful to discuss during mediation. Now, It was not until January 27th, 2025 in the decision letter that Ontario actually agreed to take into account indirect capture by using 25% of NCRRs. As a principle, this is not all that problematic for post-compensation because mathematically it actually gets us to roughly 85% of Hutchings, 25% of rents, of excessive rents. But of course, given that Ontario is starting with a $2.7 billion amount instead of a $30 or $40 billion amount, 25% amounts to be not a lot. If there's no questions on that, I'm going to move on to my next topic.
Please go ahead.
And I am making very good progress, by the way. And I thank my friends for doing that because they've left me with little to say, less to say. Turning to the legal fee issue. In oral submissions, Canada made much of the fact that they did not know that a counsel fee of $100 million was being sought. Now, the impression may have been left with the court that they had no idea that a significant counsel fee above Rule 57 costs was being claimed. And to be clear, that is not what happened. Firstly, as this court observed in discussion with Canada Counsel, I believe it's at transcript page 1572, the Crown knew in 2023 in its settlement with the Hurons that legal fees would be paid out of the settlement amount. And they very quickly knew that the amount claimed was quite substantial, over $500 million, 5%. And as this court observed, whether paid as a separate line item or not, there is only one source of the funds. So going into the engagement process, whether they knew the amount claimed by the Hurons was 5% or not, they knew that it was what was being claimed was 5% by the time they entered into this engagement session. And they may have expected a similar claim or a similar percentage amount, given what they knew at the time. But secondly, and very early on in the engagement process, and repeatedly, I might say, the RST plaintiffs told the Crowns that the full indemnity being sought was not about Rule 57 costs. And here I want to go to an early letter, October 1, 2024, in my reply compendium, tab 18. At record page 1250, excuse me, record page 1250, reply compendium page 147. And in this letter, the Crown is advised full indemnity. And recognizing that the annuity augmentation promise being fulfilled in a diligent and timely fashion and in accordance with the honor of the Crown, no court proceedings would have been needed, and recognizing the financial and emotional hardship of having to have expended costs over the years, there will be a separate line item. Now, this is what we're proposing. It's not what they, what they agreed to at the time. There will be a separate line item identified for each First Nation as a top-up for an allowance to provide for full indemnity in respect of each First Nation's costs, including all legal costs on a solicitor and own client basis, provided that the quantum of legal fees and disbursements the Crown is obliged to pay in an amount to be agreed or failing, is in an amount to be agreed or failing agreement in amount to be determined as being fair and reasonable on a quantum merit basis by the court. So the point is that they knew this was coming.
But they don't know whether you've got a 5% deal, a 1% deal, or any deal at all.
That's correct. They don't know that.
And was there ever, you say they knew that the RHT deal, they knew before the engagement process that the
They knew what the amount was.
5%.
Yeah.
But was that ever discussed when you talked about costs? Didn't-
No, I don't recall it being.
Neither
being
party
discussed.
raised it?
I don't believe either party raised it. What I can say is that there was an expectation that the amount would be identified and to be, Canada said we wanted to know the actual amount, but we didn't get that till very late. That's true. But the point that I'm making is it doesn't matter that they didn't know the exact amount. I mean, it's fair enough to say we don't know the exact amount, so we can't go to Treasury for a particular amount, but they could commit to a principle, which on December 20th, we thought they were doing in their decision letters of December 20th and December 27th. They later came out and said on January 27th that they took a different view of what the law required of them. And that's why in my reply submissions, you'll see that we just want to hold them to what we understand they committed to, which was committing to fair and reasonable fees, not fair and reasonable Rule 57 fees. Now, so the Crowns cannot credibly claim that the 40 million was in respect of Rule 57 costs. Canada made the point in its oral submissions at transcript page 1232 that the 40 million was for much more than the types of costs that would be reasonable as part of a Rule 57 court process. They knew it included costs of the engagement process. Engagement process isn't part of a court process. They knew it included non-Rule 57 expenses such as firekeeper costs, honoraria for chief and counsel, audit fees, websites, community meetings. Ontario makes a similar point in transcript page 1568. What you're left with is that the 40 million clearly must have contemplated payment towards fair and reasonable fees claimed on a counsel fee basis. Indeed, Canada says that its 20 million was arrived at before seeing the actual quantum sought, but Ontario, in its January 27th, 25 decision letter, had all the figures before it, knowing that they would only, that without the counsel fee, you're talking about $13 million. And yet, they alone contributed $20 million. So, Canada defends itself on the basis that, well, between January 24th and January 27th, there wasn't time for us to change our letter. But Ontario changed its letter. There had to have been some communication, and notwithstanding knowing by January 26th that there was 13 million in, I'll call it indemnity costs, Rule 57 indemnity costs, and 100 million counsel fee, a $40 million amount is offered. The conclusion to be drawn is that the Crowns were prepared to pay towards the counsel fee and disagreed that any more than that would be fair and reasonable. And fair enough, that's why we would have an assessment. So in truth, I say, the issue is not whether the Crowns were prepared to pay all fair and reasonable legal fees. I say they were. They just disagree that the amount claimed over and above what they've already contributed is fair and reasonable. That is why the court should order an assessment of the remaining claimed fees for fairness and reasonableness, that the Crown alone should be ordered to pay, and that should be part of the compensation in the same way as such fees would be paid, ordered to be paid as part of the losses of a plaintiff in a malicious prosecution type case.
And you say that the fee, the actual fee that you put in the letter, the 100 million,
Yes.
is not a fixed amount. It's not an ascertainable amount because I think what you're saying is that you are prepared to engage in an assessment. Assessment.
Yes, I think that that's appropriate. Now, I might think it's fair and reasonable. A lot of lawyers might think it's fair and reasonable, but a judge might not, my friends might not. And the honorable thing to do is to make sure the court's satisfied about it, even if it's, because it is the public purse eventually, right?
So where I'm trying to get is that Canada says a fair and reasonable assessment is done on a Solicitor's Act application. It's between the solicitor and the client.
Right.
Normally, here, that's not what you're proposing.
That is correct.
You're
Yeah,
proposing-
well, I am and I am not.
Okay.
First of all, under a Solicitor's Act, the people that get to show up and complain or to challenge are the people that are obliged to pay. That's what the Huron case decided. Yeah, I don't think I need to take you to it, but the position of the Hurons was, we've made an agreement. There's no basis for these other strangers to the agreement to have standing to complain about the fees. The divisional courts, the court said, no, you're wrong. These are people, it's ultimately coming out of their pockets. They have standing. That was appealed. The divisional court did not grant leave to appeal. So the answer is, and the Solicitor's Act makes clear, if you have a liability to pay a portion of a lawyer's fees, you have standing to complain about it. So under the Solicitor's Act, they would have standing. But the approach I was taking was not simply to say they have standing under the Solicitor's Act, which I think they do. The approach, and so would my clients, and so would anybody else who has an interest in, or who has an obligation to pay. But because I am saying the only person that should have an obligation to pay here is the Crown, it's they who would be the objectors, so to speak. But it's not just because of the Solicitor's Act. It would be because as part of the compensation payable and consistent with reconciliatory justice principles in Takuhikan that call for flexible and creative approaches that repair the relationship. In a relationship where not one penny would have had to have been spent on me and any of the other good lawyers who have worked on this case. Full indemnity should be the decision. And it should be based on the same analysis as other relational agreements like insurance contracts or malicious prosecution cases where the state does wrong. So I've already dealt with the Crown's having standing. And what the RST and Anishinaabe seek by way of an assessment as to fairness as reasonableness is similar to what happens in a class action settlement. Now, I think Your Honor kind of alluded to this when by making a reference to class action proceedings. Now, of course, a representative proceeding that we are in is a class proceeding, but it's done as a representative action instead of a class action under the class action rules. But by analogy, the idea that sometimes it makes sense to have the lawyer's fees assessed for fairness and reasonableness, that's right in the Class Action Proceedings Act. Now, those don't apply, but it makes sense given we're talking about the public purse that there should be an opportunity for the Crowns to make their case, and obviously for me to establish to the court's satisfaction what amount is fair and reasonable. But I want to take you to the Tatasquiac case. It's at tab 19 of my material. That was the clean drinking water class action. And what happened in that case, and if you look at compendium page 150.
Could you just spell the name for the report?
Yes, I could if I look at the case, Tatasquiac, Tataskweyak, Cree Nation. So over at paragraph 7, the judge refers to the settlement agreement, and it says part of the settlement agreement with the federal government was subject to, and I'm reading from the agreement, which is identified at paragraph 7, compendium page 150, subject to approval by the courts. And within 60 days of an implementation date, Canada shall pay class counsel the amount of $53 million plus applicable taxes in respect of the legal fees and disbursements for the prosecution of the action to the date of settlement approval hearing, together with advice to class members regarding the agreement and acceptance. Then there's a paragraph about ongoing fees. And then there at the bottom of that page, under 18.02 sub 3, class counsel shall report the balance of the funds held in trust for ongoing fees to the courts and Canada on a semi-annual basis. So for Canada to retain a role in what the lawyer's reasonable fees should be where the public purse is engaged is not an unusual concept. And the analogy to Tatasquiac is an apt one, even though we are not in the class action world. The idea of the Crown's paying full indemnity so that the money doesn't have to come out of the pockets of the First Nations who have been the victims is a good one. Ontario, in oral submissions, argued that the court does not have authority to make a legal determination that they are obliged to pay fair and reasonable fees because this is just a judicial review of an administrative decision. You'll find that argument at transcript page 1568. Here, Ontario is wrong. The Supreme Court of Canada made clear that if the past compensation amount is not constitutionally compliant, the court can craft an appropriate remedy. Now, we said much more on fees in our reply compendium, which we continue to rely on, which Canada and Ontario did not comment on, and we will not.
Your reply factum, perhaps?
Yes, our reply factum, I'm sorry. In our reply factum, my apologies, which we continue to rely on our reply factum. Those were not challenged by the Crowns, and we are not going to address them now. I want to now move to the next topic of, unless there's any questions, I want to move to the next
No,
topic.
thank you. Go ahead.
I want to deal with Canada and Ontario's rejection of Hutchings as a witness. First of all, I take objection to my friends referring to Mr. Hutchings as a quote unquote professional expert witness. That happened on 2 occasions in Canada's submissions at transcript page 1054 and 1074. And you'll find those transcript pages in tab 2 of the reply compendium. The implication, I believe, sought to be left was to convey that Mr. Hutchings' evidence was not delivered in an objective, fair fashion, and that he was little more than a hired gun. Now, having sat through the evidence, I do not believe that such a characterization is fair or consistent with how the experts presented at trial. I will leave it for the court to decide on which of the experts testified in a credible, believable, and reliable manner and which did not. Next, Canada made a joke about an economist and a can opener on a desert island. Now, recall that the joke is about the economist's solution is to assume the existence of an imaginary can opener. Respectfully, that's an inapt analogy. Firstly, Stiglitz and Hutchings did not imagine the historical data. They dealt with the data that was available. They grappled with it. They analyzed it. They weighed it, and they brought their expertise to bear on it. Secondly, the problem facing the economists on the desert island was not to open the can of beans. Their task was to opine on how many beans were in the can. Thirdly, the only reason the economists had to estimate the beans in the can on the island is because the Crown failed to do the one thing they were supposed to do, which was to bring the can opener to the island to keep track, and to keep track of the beans in the cans. So I submit the proper story about the economist on the island is that there was not simply one can of unopened beans on the island. There were 95 opened cans of beans for the period 1850 to 1945, and a number of an unopened can of beans. So what Hutchings did is he picked up the unopened can of beans. He felt, or bean cans, more than one. He felt the weight that each can had. This told him something. It told him that there were some beans in the can. He also had data proving that after 1945, more beans were being produced by the bean factory. And he also noticed that the cans after 1945 were much larger than the older cans. Now, he also looked around and couldn't find any data suggesting that the cost of tin cans into which the beans were put were rising in cost. And he had no data suggesting that the cost of beans had risen exponentially. What he did was what any rational and reasonable person would do. He looked at the amount of beans that were in each of the 95 opened cans and came to a sensible conclusion or two. The first thing he concluded was, on the balance of probabilities, the unopened cans were filled to the same approximate level as the open can of beans. And he also formed the not too astounding opinion that the unopened can of beans did not have negative 8 billion beans in them. Turning to throwing out the baby with the bathwater. On June 10th, 2025, Counsel for Canada argued that one can ignore that the Crown's economic experts and their opinions did not withstand scrutiny at the Stage 3 trial, and that their opinions should still be relied upon because the Crown economic experts were highly credentialed and internationally renowned economists. That's transcript page 1076. Respectfully, that is not a logical proposition. There are many people with fancy degrees from very nice universities with many awards to their names, and I would not trust them with a can opener. In every instance, trial-tested evidence trumps agreeing with someone because they have a degree. But the court can take an important message from the proposition presented, because The ministers likewise were inappropriately swayed by the appeal of Bodway and Smart's degrees. It puts their reasoning path into question as being based on illogical considerations. Why did the ministers think that Bodway and Smart were so much better and should be relied upon? My friend says, don't throw out the baby with the bathwater. Now, rather than me suggesting that the Crowns have been guilty of drinking their own bathwater, I can accept my friend's analogy, and I'd say this. When one throws out the dirty bathwater in this case, what one is left with is a few highly credentialed economists sitting in an empty bathtub. The ministers failed to grapple with this. The evidence from Booth and Smart was not worthy of consideration, and the ministers, whether they perhaps didn't know what happened in stage 3, but they were not there, they did not have the benefit of seeing what happened. Today is not the time or place to point out all the frailties of Bodway and Smart's opinions, but it was on display in stage 3 and fully dealt with in closing on oral submissions in stage 3. Turning now to another topic. Just to let the court know, I think I might have about another hour and a half to go, maybe at most.
Okay, should we take lunch then till 2?
Yes, we can do that, yeah.
Okay, and then we'll come back this afternoon, and you are signaling that you will be done today then?
I am signaling I will be done today.
Very good. So we'll take that away, Mr. Bass, whatever that message is, if you have something on with your clients. Okay, thank you all till 2 o'clock.
This court is to down until 2 p.m.